Kopp, who is a partner at Coughlin Gerhart. And now, Nate, you and your colleagues at Coughlin Gerhart have spoken to us before about many different aspects of estate planning and generally making preparations for how a person's affairs might be handled after they pass away. Something that we haven't really talked about is estate planning for business owners. If you own a business, do you need to approach your estate planning differently?
Passing down a business is not like passing down some other gift under a will. It comes with a lot more responsibility, and it requires specific planning. You don't want to end up in a situation where an otherwise lucrative business ends up being more of a burden than a benefit on the next generation.
And that sounds pretty daunting.
It doesn't have to be. Most business owners have a pretty good overall understanding of what needs to happen to pass things down smoothly. It just takes a little forethought and getting a plan down in writing in a clear way.
Okay, so what do they need to do? Like, so say something specific in their will about who gets the business.
It's probably better than doing nothing, but there are better ways to do it. I would start with looking at what plans they might already have in place, even if they don't know about it. The first thing they should do is identify what kind of a company they have. Is it a limited liability company or an LLC? Is it a corporation? Is it a partnership? Is it just a business that they're running under their own individual name without having set up a formal legal entity? Depending on the answer, they might already have legal documents in place that say what is supposed to happen to the business when they pass away. If they did go through the formal process of setting up a distinct legal entity, then they may have corporate documents like an operating agreement or a shareholder agreement with bylaws or a partnership agreement that includes language that says what's supposed to happen when an owner dies. These are standard and often required by law. If you don't have one of these or you think you might have done one at some point but just can't find it, it's usually a good idea to do one. They contain all the terms for how the business is supposed to run legally and on a day-to-day functional basis.
Okay, so it makes sense that a company is supposed to have handwritten documents that set the rules for how it runs, but that seems like a different thing than planning a future where the owner isn't around anymore. Do you really have to go dig through all of that, or can't you just make some kind of new plan to your will?
You're right, it does seem like a different thing, but the reason to start with these documents is that they often contain language that will control what happens when an owner passes away. The language in those documents can override any instructions that somebody might set up in a separate estate plan. For example, somebody might have set up an LLC many years ago and used some form operating agreement that they found from whatever source and then never looked at it again. If that operating agreement happens to contain any language that says what's supposed to happen when the owner passes away, that's the language that will control the outcome, not whatever they say in their will.
Okay, so you should figure out what the corporate documents say first. What if they don't say anything about what happens when the owner dies, and at that point, can the person just state what should happen with the business in their will?
That is one option, and it can work. We sometimes see language in these operating agreements and other corporate documents that say specifically when an owner passes away, his or her interest is supposed to pass according to the terms of their will.
So that does sound pretty useful. But what if you have like business partners? Do they have any say over who gets to share the company after your death? And by the same token, shouldn't you have some control over who they might name to receive their portion of your company?
Yeah, there are many scenarios where you might not necessarily want to be forced into accepting a new business partner. You can account for this with terms in those same corporate documents that we've been discussing too. You can include specific instructions in those documents that say things like who is even eligible to take over an owner's share. For example, if it's a family business and you want to keep it in the family, you can say that in your corporate documents. You can say whether the other owners get a right to buy your interest first when you pass away. And if so, how that value is going to be set and how that process is supposed to go. Terms like these are commonly referred to as buy-sell terms, and they can be as general or as specific as the business partners want them to be.
And it sounds like things could get kind of complicated with that.
Yeah, sometimes they can. It really depends on how detailed the business partners want to be with their planning. It can also be very simple. For instance, I've seen several companies that are owned by spouses or siblings where Everybody knows how everything operates, and each owner just wants to leave it to their business partners when they pass. You can do that by including those terms in a simple way in those corporate documents, or you can make your collective ownership of the company joint, like you would with a joint bank account. This is another way that you can make sure that your ownership interest passes without having to go through probate.
Okay, so everything you're proposing seems that you just kind of needed to get it down in writing, regardless of whether it's simple or complicated.
That's exactly right. If you want to make sure that your business is in good hands and continues to function well after you pass, then you need to get it in writing in a clear way.
That makes perfect sense, and thank you so much for being here with us today.
It was my pleasure. Thanks for having me.